Hello, this is Ifoma Odulami, immigration attorney from the Odulami Law Firm in New Jersey. My law firm serves clients in all 50 states, and we're located in New Jersey, but we have clients from all 50 states. So today I have a really great topic. I'm going back to the basics of family-based immigration, and I haven't done this in a long time, but I keep getting questions from people such as, can I file for my grandchild? Can I file for my niece? So I just thought that it would be a good idea to go back to the basics. I did this video maybe about 2 or 3 years ago. So going back to the basics of who you can file for if you're a U.S. citizen or a green card holder. So I'm just gonna, talk a little bit more about the filing process from the standpoint of either if you're a green card holder or if you're a U.S. citizen, or if the beneficiary, that's the person who wants the green card, is in the United States or abroad. So, hi everyone. Let me go to the comments so that I can see when you post a comment. Feel free to post a comment. Tell me where you're tuning in from, and get ready for this great topic. So, now to be clear, there are different ways to come into the United States. I'm just talking about family-based, okay? And even as I'm discussing family-based, there are always some kind of exceptions, which if I have some time, I'll get into that. I hope I remember. So for starters, right, family-based immigration, there are two main categories. There's immediate relatives, and then there's family preference. So immediate relatives is a U.S. citizen filing for a spouse, their U.S. citizen who is 21 and above filing for their parent, and a U.S. citizen filing for their child who's under 21 and unmarried. So this group is called the immediate immediate relative. There's no waiting period at all. That's the big thing that differentiates it from the second category, which is family preference. There's no waiting line. So you go ahead and you file for your family member, because the visas are always available for the immediate relatives. Now, family preference goes into 4 categories. There's F1, right? F1 is a U.S. citizen filing for a son or daughter. Now, a son or daughter is what immigration terms children who are over the age of 21, right? So F1 is a U.S. citizen filing for a son and daughter who is unmarried. Key point, okay? F2 is actually divided into 2. F2 is F2A and F2B. F2A is a green card holder filing for a spouse and children who are under 21. And F2B is a green card holder filing for their sons and daughters, children over the age of 21, right? And unmarried. It's very important, all right? Because if you're a green card holder and your child is married, you cannot file for them. Neither can you file for your parents as a green card holder. So these are important things to know, okay? Then F3 is a U.S. citizen filing for their sons and daughters. Married, single, doesn't, sorry. So, F3 is U.S. citizens filing for their married children, right? So that category allows, is actually, there's a wait period for that, which is really funny because it's, as a green card holder, if you're filing for your spouse or your children under the age of 21, there's no wait period now, right now. It hasn't always been so, but there's no wait period right now. Meanwhile, if you're a U.S. citizen filing for your children who are married, there is a wait period. So F4 is brothers and sisters of U.S. citizens. So this is a U.S. citizen filing for their siblings, right? And it doesn't matter if they're married or they're single, but you're filing for your siblings. And this is the longest wait in all of the categories, okay? So there's something called a priority date. When you file your petition, which is typically the Form I-130, you get a receipt. That receipt gives you your priority date. That's the date that your case will be attended to when uh, uh, USCIS or Department of State is processing your the applications. So for family-based, for the family preference, the visas are not always immediately available. I mean, right now it's available for F2A, and it's been available for F2A for a few years now, but it hasn't always been available. So until your priority date is reached, you can't really do uh, much more work on the immigration process. So with all the immigration processes, you're starting your filing with filing a Form I-130, right? In the case of uh, uh, a family-based immediate relative, there's nothing to wait for. So if you're in the United States, you can file an adjustment of status at the same time, right? If the beneficiary is in the United States. If the beneficiary is outside the United States, then they have to go do it through something called consular processing, right? So I just want to make sure everybody's following with me, and because I'm trying not to make it really confusing, so let me just give you the basics, right? So we've talked about immediate relatives, and we've talked about family preference, right? So the next thing we're going to talk about is um, how you can get your green card, whether you can file for adjustment of status because you're in the United States, that's the beneficiaries in the United States, or you have to do a consular processing. So consular processing is typically for beneficiaries who are not in the United States. They're outside the United States, and it's called consular processing because, you're going to get your green card through, you're going to go have your interview in the American consulate in your country, or maybe in a third country, depending on what the problems, or if there are any problems in your country. So that's how that goes, right? So adjustment of status is for beneficiaries who are in the United States. But everyone does not qualify for adjustment of status. So if you're in the United States and you have a US citizen family member or a green card holder family member, the first thing you want to figure out is whether you as the beneficiary qualify to adjust your status in the United States. So if you're in the immediate relative category, it typically does not matter if you've overstayed, if you've stayed longer than you were allowed to, if you came in with a visa. If you didn't come in with a visa, if you were not inspected or paroled in, then you cannot adjust your status in the United States. You will have to do it by consular processing, which means you would have to leave the country, and that requires you to file a waiver or forgiveness so that you're allowed to come back in. And that waiver is if you're filing a waiver for unlawful for overstaying, that's Form I-601A. So now, if you are from the preference group, you could adjust your status, but it requires you to have to be maintaining and have always maintained proper legal status. So if you came in as an F1, or maybe you have a work visa, and you've always maintained legal status, and you haven't fallen out of status, you can adjust your status if you're on the preference, as long as your priority date has been reached. However, if you're not in status, you cannot adjust your status in the United States. You must do it by way of consular processing, which means you're going to have to, at some point, leave the country and come in. Now, you cannot leave the country without a waiver, because if you leave the country, you might be subject to some inadmissibility, such as the 3-year ban or the 10-year ban, or some other kind of ban based on whatever the inadmissibility issue is. So it's important that if you're looking to file for your family member as a US citizen or a green card holder, you want to determine, first of all, where are they? Are they in the United States? And if they're in the United States, can they adjust their status? Do they qualify to adjust their status? And if they don't, can they do it by consular processing? Do they qualify for a waiver? Now, for you to qualify for a waiver, amongst other things, you have to show that there's going to be extreme hardship to the US citizen if you're not allowed to come back in. All right. So that's in a nutshell. Uh, that's in a nutshell what the family-based preference is and what the immediate relative petitions are. Now, I was going to tell you that there's some people. I remember a case where somebody had asked me if she could file for her niece, and I said, no, you cannot file for your niece. That's not part of the family based petition. However, the more information she gave me, I realized that there was a humanitarian way for her niece to get her green card through something called special immigrant juvenile status. So sometimes you may not qualify for a particular green card through a family member, but you may qualify for a humanitarian uh, based green card, such as the U visa, which is for crimes, victims of crimes, the T visa, which is for victims of labor trafficking or sex trafficking, asylum, and other humanitarian type visas. So it's important for you to have a proper consultation so that you know if you or your family member can fall into either some type of humanitarian based green card if they don't qualify to get a green card through a family member. So hi Nkechi, how are you? Thank you for signing in. So let's see if anybody has any questions so that I can answer it. I don't see any questions here. So let's see if I have any other thing to add. Um, so let's talk about the process for consular processing. So that might be a good one to discuss. So consular processing typically starts if you're filing for a family member by filing the form I-130. If it's a spouse, you have to include the I-130A. When the I-130 is approved, and what the I-130 really does is approve the relationship, right? You say you're married, they approve the relationship because you've shown that it is you're married to this person, right? If you're filing for your son or your daughter, the relationship is parent child. You have a birth certificate, and you're able to show that. If you're filing for a spouse, I think I mentioned that before, a spouse, or you're filing for your parents, same thing. You need a birth certificate. So the I-130 is really just the beginning of the process, and all you're doing is establishing that relationship exists. Now, in consular processing, once the I-130 is approved, the case goes to the National Visa Center, or NVC. And there at NVC, NVC requires certain other information from you that you need to upload. And once you upload that, they will let you know if you have satisfied their requirements. And they tell you that when they send you an email saying that you're documentarily qualified. Now, if your priority date is not reached, you're not going to be able to go through the NVC process. So NVC will send you a letter telling you that the case is with them, but nothing's going to happen until your priority date is reached if you're in the preference category. So once your priority date is reached, you will get another letter from NVC telling you that you may proceed. And at that point, you can log up onto their website. You can pay the filing fees, and you can begin to upload your documents. Once the NVC has determined that you're documentarily qualified, then they will move the case to the American embassy in the country where you live, which is where you're going to have your interview. So that's pretty much what the adjustment, what the consular processing is. Now, you go for your interview. There are other things that you need to do. Once you go for your interview and you're approved, you get a stamp on your passport that allows you to come into the country. You come into the country, you pay your Ellis fee, you get your green card, the green card itself a few weeks later. Now, the adjustment of status process, which happens in the United States, typically you file the form I-130 and you file the adjustment of status simultaneously in one step. And during that process, you will get a work permit. You will also get an advanced parole if you applied for that. And the advance parole allows you to travel in and out of the country while your case is pending. Now, I tell people that remember that the advance parole does not automatically let you in. So even though you have an advance parole, permission to travel, if you've done something that makes you inadmissible, that could present a problem. You may not be allowed to come back in. So just because you have an advance parole does not mean they're automatically going to be allowed to come back in. They get a chance to reinspect you again when you come to the border. And at some point, you'll be called for an interview. And after the interview, if the interview is successful, you will get your green card. So that's how that process works. So, hey, Lisa, how are you? Nice to see you. So that's pretty much it. I think I'm looking to see if there's any other question, but I just wanted to talk about this because you cannot file for your grandchild unless you adopted that child legally. You can, the other questions I get is, can I file for my stepchild? Yes, you can file for your stepchild, but this is the funny thing, right? With immediate relatives, there are no derivatives, which means if you file for your wife, you also have to file a separate petition for the stepchild. Your stepchild doesn't get any benefits from you filing for your child in the immediate relative category, right? And you can only file for that child if the relationship, the step relationship happened before the child turned 18, which means that you married the parent before the child turned 18, then that child qualifies as a stepchild. Now, in the preference category, what was I going to say? I'm losing my train of thought. Okay, I forgot what I was going to say. But yes, you can file for your stepchild, you can file for your step-parent, you can file for, and you can even file for them, even if you're divorced from the parent, of the child, subject to, certain exceptions. You can file for them if it's a VAWA case. You can continue to, it doesn't matter if you have any relationship with that step-parent, you can file if you've been abused by that step-parent. Otherwise, USCIS requires that you continue to have some form of relationship with the step-parent to be able to file for them if they're divorced from your parent. So that's really it for today. If you have any questions, please feel free to call my office, 973-993-1900. Follow us on social media, Instagram, Facebook, YouTube. Don't forget to subscribe so that whenever I come on, you get notification. Take care, everyone.